these circumstances, dereliction of duty, things like that. Congress doesn't have any role in setting those protections. And so the constitutional question that was raised by Morrison v. Olson is completely absent in the special counsel here, which means that even if we say, Justice Scalia, has wrote this opinion, which we think now is really the law because implicitly it's been adopted in these other Supreme Court cases. Even if we think that's true, that wouldn't support Judge Cannon's decision at all. And so I think the lower courts and we as lawyers and constitutional observers need to be very careful about making sure that we are extremely parsimonious about understanding how prior Supreme Court precedents, if they've been overruled, how that then expands out into the way that it might affect other issues like the one here.
Josh, what is your response to Matt's 2 points? First, he says lower courts are supposed to apply existing precedents and not predict how the Supreme Court might rule. And then he says when applying contested precedents, they should be careful not to discard them ahead of schedule. And in any event, Morrison doesn't cover this case. Your thoughts?
Well, I have chutzpah, Jeff. So I put up in open court. Matt's smiling. You can't see this in the podcast, but he's smiling. So I actually went up in open court when we argued, and I said that I would like to preserve the issue for the Morrison should be overruled. I think it should be overruled. I think it's been correctly decided. I know, of course, a trial court can't do this, but it's useful for a trial court to at least note that this precedented issue. That way the parties have due notice. And in fact, in a footnote, Judge Cannon cited me making that request. So, of course, the district court can't overrule Morrison. The 11th Circuit can't overrule Morrison. Maybe the Supreme Court will. But I think Judge Cannon actually avoided the question of whether Morrison should be overruled. She didn't even touch the issue of whether Smith was principal or inferior. She sort of just assumed he was. And I think that was sort of tactful on her part. But I do think that judges can sort of, read the writing on the wall. I'll just give you an example. After United States against Windsor, right, the court struck down the Defense of Marriage Act. And the majority opinion said, we are not saying anything about same-sex marriage. Justice Kennedy, trust us. We're not talking about that. No one believed him at the time. But within like 5 seconds, all these district courts started saying, aha, Baker v. Nelson. This was a precedent that said there's no right to gay marriage, kind of, more or less. They said, we're just going to treat it as being abrogated. And all these district courts sort of went wild. And one after another said, no, gay marriage, gay marriage, gay marriage. So courts do this all the time. I don't think it's unusual to sort of read the writing on the wall. I think Judge Cannon was actually more careful than a lot of these other judges have been. But as this case goes upstairs, this will come up. And look, even if Trump loses the election, we will have an opportunity to attest this issue not in the Trump context. Robert Mueller never actually indicted Trump, so we never got to test that one. But someone will be prosecuted. And I think this case will get to the Supreme Court sooner or later.
Matthew, as Josh mentioned, you both argued before Judge Cannon on this issue, and you also filed a powerful brief making a series of arguments for why Special Counsel Smith was appropriately appointed. Can you share the other arguments that you made in your brief and before Judge Cannon?
So there were several issues that came up that were implicated in this broader issue of the lawfulness of Special Counsel Smith's appointment. The first, which Josh has alluded to several times, is what is the proper categorization of the special counsel? Is the special counsel a principal officer? Is the special counsel an inferior officer? Or is the special counsel, as the cases call it, a mere employee? Because the legal procedures that are required for the appointment of these different levels of officials vary. And so all three positions were asserted in the case. So, as Josh mentioned before, Attorney General Meese and his co-amici argued that the special counsel is a principal officer. Why? According to Attorney General Meese, well, it's, the special counsel has so much authority, isn't really answerable to anybody else, doesn't really have a boss, and as a result of that is a principal officer and thus must be appointed by the president with the advice and consent of the Senate. On the other end of the spectrum, Josh, and I'll let him make his argument that he's already alluded to a couple of times, says, no, Special Counsel Smith is a mere employee because he's not sufficiently continuous in his job and sufficiently permanent, although I know Josh says that permanence is not the not the real important factor here. And therefore, the special counsel can't wield the level of power that the special counsel does. That's got to be done by somebody who's an officer of the United States, whether it's principal or inferior. And, because Jack Smith is not an officer, because he's only a kind of temporary gig employee, we might say, that's too much power for the prosecutorial equivalent of an Uber driver. So so that's this threshold issue of the proper categorization of the special counsel. Now, Judge Cannon did say that she was bound by precedent on this. There is precedent that says that the independent counsel, the special counsel, is an inferior officer. Why? Well, because the special counsel has a boss. The boss is the Attorney General. Now, unlike the old independent counsel, which is where that was Morrison v. Olson, which addressed this point, among others, the independent counsel had a lot of independence from the Attorney General. The special counsel has some independence, but that independence is something that the Attorney General can reverse at any time. Merrick Garland today could issue a letter saying that I am changing the rules for the special counsel. I can fire the special counsel at any time. Now, he hasn't done that as a matter of policy because Attorney General Merrick Garland, like many attorney generals previously, including Ed Meese, has made the policy decision that it's important to have a certain amount of discretion and independence for these politically sensitive types of investigations. That's exactly why Merrick Garland appointed Robert Hur as a special counsel to investigate the president's son, Hunter Biden. And so there's this threshold issue about what the proper constitutional categorization is. Judge Cannon said that she was bound by Supreme Court precedent to hold that the special counsel is an inferior officer. So that's one issue we argue. And then there's the issue we've engaged with throughout today, which is, okay, so if Smith is an inferior officer, what do the statutes say?
So I'll try to summarize the different positions that we've discussed so far. Jack Smith argued, and Matthew, you agree, that his appointment is constitutional because he is an officer and his appointment is authorized by congressional statute. Justice Thomas and Judge Cannon argued that Smith is an officer and he's subject to the Appointments Clause, and Congress has not clearly authorized his appointment. And Josh, you argued before Judge Cannon, making a third argument, which is that Smith is not an officer at all, and because officers have to serve continuously, and because his appointment is temporary, he's at most an employee. Tell us more about your argument and why you think it's correct.
Sure. And I appreciate Matt. I think he did actually a very careful job describing the position he disagrees with. That's a talent that people don't always have. So I'm thankful for that. First off, it was unusual to have amicus make arguments in a district court. Not just one, not two, but three. So Matt was up there, I was up there, and also lawyer Gene Scher, who represented General Meese. And I'll make this point. I thought Judge Cannon was pretty tough in all the parties. She was curt with me a couple of times. I may have annoyed her a bit, and that's fine. That was part of the process. But I thought it was actually a very thoughtful engagement. She was well prepared. She knew all the arguments. She had a very good command of the law. Her opinion came out not too long after the argument, so I think she'd already done a lot of the hard work. And this was to sort of clean up some loose ends. So I'm grateful for the chance. My colleague and I, Seth Barrett-Tillman, and the Landmark Legal Foundation, we put an amicus brief in. And Seth and I have been writing about officers of the Constitution forever. I think I've been on your podcast, Jeff, several times. We talked about the Emoluments Clause and officer stuff. We talked about Section 3 insurrection and officer stuff. And now we're talking about special counsel and officer stuff. I feel like I'm stuck in this time loop. I can't escape it. The argument's like this. What is an officer, right? The Constitution talks about officers of the United States, office under the United States. But what actually is an office? And there's a line of cases going back to the early 19th century saying that an office has what's called duration, right? That is, when the current holder of the office finishes his job, and maybe he leaves or dies or retires, that the position continues and someone else holds that position. In our view, this phrase officer is linked to the phrase officer of the United States in the Constitution. So you cannot be an officer of the United States if your position lacks duration. Why does this matter? We argue that Jack Smith, who's been here By the way, if I call an Uber and Jack Smith shows up, I'm calling another car. But Jack Smith has been here for a long time, for a couple of years now, but his position lacks any sort of duration. What's unique about the independent counsel statute is actually there were provisions for duration. Everyone knows Alexa Morrison, but she wasn't the first one picked. It was actually a guy picked before her. And when he stepped down, the process for replacing her was actually baked into the regulations and the what's called the special division of the DC Circuit to replace the person. So we argue that actually the independent counsel is different from the special counsel, right? There's different regimes of how there's continuity. And why does this matter? It matters because Jack Smith keeps calling himself, I'm an officer, but we really think he's an employee. And as an employee, we argue that he can't exercise the broader power that he's exercising, that of a United States attorney. And there'd be problems if that Congress can create these shadow U.S. attorneys that don't go through confirmation. They're just appointed for temporary positions to exercise his power. We think that that's problematic. Our position, I don't think, requires overruling Morrison. I think it's consistent with Morrison. Judge Cannon disagreed with us. Trump's lawyers disagreed with us. But not the first time that's happened to me and Seth. We seem to always be on the outside, but yet we always we go away into these various debates. It seems to happen over and over again.
Matthew, we've talked about the various positions ranging from whether or not Smith is an officer and whether he's subject to the Appointments Clause or whether he's not an officer. Step back, please, and tell me, how broadly do you think Justice Thomas and Judge Cannon's opinions would sweep if they were adopted by a majority of the court? Might they call into question special prosecutors, including the special prosecutor in Nixon itself? Or would you expect them to be limited to Jack Smith and outside counsels?
I think, as we discussed before, this decision is, I think, limited to, or at least as it stands, this decision is limited to special counsels or other special prosecutors who are appointed directly from outside the Department of Justice. Now, when I say that, it's because it hasn't yet been contested whether the statutes, Section 515A, gives the authority to take someone internal to the Department of Justice and then make them into a special counsel. Now, I suspect if the Supreme Court ruled in favor of Mr. Trump in this case, that would be the next thing that happens. So it's hard to predict exactly how far that would go. What's certainly true is that it's not limited to Smith. And so any other special counsel that's hired directly from outside the government, any other inferior officer in any other part of the Department of Justice that's hired directly from outside the government, like the Deputy Assistant Attorneys General, like the Deputy Solicitor General, and so on. And it also does raise questions about other departments, because if we're going to start looking very, very carefully at the statutes that other department heads, like the Secretary of Homeland Security or the Secretary of Defense, we have to look very carefully at the statutes that have been relied on to appoint inferior officers in these other departments. Now, I think there is statutory authority in all these other departments, and I hope that those appointments would survive. But it certainly calls into question, well, okay, are these similar types of arguments going to be made about actions taken by inferior officers in every other department of the United States government?
Josh, do you agree or not that the argument might sweep more broadly to call into question these other inferior officers? And does the radicalism of the suggestion, or the fact that it would disrupt a great deal of settled practice, count against embracing the argument or not?
I tend to think that if the Supreme Court should ever get this and find Judge Cannon to be persuasive, they could cabinet to those appointed outside the government. And this is a point that's relevant. Jack Smith, in his brief, describes sort of this long history of special counsels being appointed by the government. But the history there is actually a bit more complicated. A lot of these people were not actually prosecutors. They were just investigating. They were writing reports. Maybe they were working underneath a U.S. attorney. They were assisting them. So really, there are not many examples of a person plucked from outside government and given basically the entire panoply of powers of a United States attorney to prosecute someone. They're only, before Watergate, it's tough to find a good example like that. And after Watergate, you had the independent counsel statute. So really, we're talking about Jack Smith, we're talking about Mueller, and maybe one or two people from the 90s, and then we have, of course, Jaworski, but there are problems with that one as well. So there's not a long